Robert F. Kennedy Jr. may not be on your presidential ballot. A state judge ruling against him, saying that he used a false and, quote, sham address to claim that he lives here in New York, when in fact he does not. The judge said that the spare room that he rents inside a friend's home for $500 per month was not his bona fide address. He lives in California. His legal team, though, is vowing to fight on, and RFK Jr.'s attorney is here in studio with me tonight. First, though, what the candidate himself said about all of this just before the judge's decision.
I always kept New York residence because I love New York. It's part of who I am. It's part of my identity.
But a state Supreme Court judge in Albany put out this blistering judgment following a trial. In the 34-page ruling, she said, quote, using a friend's address for political and voting purposes while barely stepping foot on the premises does not equate to residency under the election law. To hold otherwise would establish a dangerous precedent and open the door to the fraud and political mischief that the election law residency rules were designed to prevent. Here to react to that tonight is William Savino, a Buffalo-based attorney who represented and continues to represent RFK Jr. in this case. Thank you for coming in. Good to see you.
You're very welcome.
So
Thanks for asking me.
I read the 34 pages. I'm not an attorney. You are. Certainly, the facts as they seem to have been presented in the case, to a layperson, I think would say, well, yeah, RFK Jr. lives in California. He doesn't live in New York. Why then did he say he lives in New York?
He said he's a New York resident. And he's particularly a New York resident for purposes of the 12th Amendment, which controls how we elect our presidents. And that law looks to something called inhabitant status. And he's an inhabitant of New York because he's always been adamant that he's going to return to New York as soon as he can. And that's the test constitutionally. But unfortunately, our judge, and we disagree with her, said, I'm not going to consider the constitutional arguments, even though they were in our papers, even though they were argued by me. She said, I'm going to decide this on New York election law. But New York election law is subordinate to our Constitution.
She does say in the ruling, she addresses, and very briefly, I mean, in the 34 pages, it's really just a couple of paragraphs, but addresses that constitutional question, disagreeing with your interpretation of it. But it sounds to me like that's what you're going to argue now. I guess it's not really an appeal, it's really taking it to federal court. Is that what's next?
We have multiple cases going. We have a federal court case in New York City, which is suing the state because the law, as applied by the state, is unconstitutional. That's live. We have an appeal of this decision, which will be heard by the 3rd Department in Albany. And we have an initial trial coming up next week. I'll be in Mineola defending another bunch of petitioners who claim that the signatures taken aren't effective because the petitions were folded when the signatories signed the petitions.
So multiple aspects to that. Just kind of backing up to what is at the heart of this case. When RFK Jr. sought to be on the ballot in New York, he had to go out and get petitions, right, get signatures. And it was in those signatures in which he said, I am a New York resident. To anyone who would have been signing that, to whom he was saying, I'm a New York resident, he really doesn't live in the state of New York.
Let's turn that around.
Is that the problem here?
Let's turn that around. Some of the case law that we presented to the judge, which the judge chose not to follow, says the test is, are voters misled? Are voters confused? No voter testified to being misled or confused. And our argument to the judge was, there is no harm, and they couldn't show any harm, and where there is no harm, the petition shouldn't be struck. This petition with the New York residency was blessed by his ballot access attorney. And the ballot access attorney told Robert F. Kennedy Jr., put down New York. That's the only state that we can use in all 50 states because many states require that you list as residency the state where you're registered to vote. And he's registered to vote in New York, and he's voted here right into the 2020s.
Which sort of brings me to the question, why has he been voting in New York if he really doesn't live here? He spent like one night at this home in New York, right?
But that's since 2014, since he got married to Cheryl Hines. But the two of them are determined to come back here when her career ends, as all careers do. And this man, you have to be around him. His passion for New York, his father, when assassinated, was the senator from New York. And the outdoorsman activities by Bobby Kennedy in New York are unparalleled. He loves this state.
In terms of what happens now, we're talking to you because obviously there are RFK Jr. Voters out there who would like to vote for him here in New York in November, but obviously New York is not a battleground state, and it goes far beyond that. Do you worry about the ramifications this ruling will have in other states where perhaps his candidacy could be more of a factor?
I have to. I'm not doing work outside New York, but it is a concern. But I want to circle back for a second. There were 9 attorneys in Albany all week against my partner and me, my partner Mike Ostrander and me. 9 attorneys. The petitioners weren't paying them. The Democratic National Committee, through Clear Choice, was paying them. So this is carpet bombing. The Democrats are doing anything they can to keep Bobby off the ballot. And you know, this is a First Amendment issue. People have a right to be heard. People have a right to vote for whom they choose.
Finally, in terms of what's next, are you confident that you can win this? And if not, is RFK Jr.'s candidacy essentially over?
I don't want to talk about his candidacy. I have no authority and no knowledge. But we think we should win the appeal in Albany because there were many things that the judge chose not to look at or to properly consider, such as the innocence of the listing of New York. And many of the cases say there has to be this bad intent, fraudulent intent.
Attorney William Savino represents Robert F. Kennedy Jr. as he is fighting for ballot access here in New York. Thank you for coming in. We really appreciate it. Good to see you.
You're very welcome.
Thank you. All right, and joining me now with reaction to that conversation is Professor Sean Donahue, who teaches about law and politics at the University at Buffalo. Dr. Donahue is actually live now in Kyiv, Ukraine. We appreciate you staying up late for us. I know that you've read the judge's decision, followed this. You just heard RFK Jr.'s attorney's response. What happens next in your view?
Well, the state Supreme Court judge in Albany County, her opinion was pretty blistering against Robert F. Kennedy Jr. As his attorney was saying there is the next step would be an appeal to the appellate division. And then eventually, if not successful there, either side could appeal to the New York Court of Appeals, as well as potentially bringing a case in federal court.
So as you look at the ruling from the judge, do you see grounds for appeal? Do you agree with the attorney here who says that essentially this was decided incorrectly and that RFK Jr. should remain on the ballot?
Well, in reading the opinion, it's, I was writing down some of the quotes that she used here. For instance, one of them was merely a sham address for purposes of maintaining voter registration and furthering his own political aspirations. Really, she went, what I saw is that she went in very great amount of detail in saying things such as that really having a spare bedroom in a residence really does not show intent that he is intending to come back with his family, his pets. She even goes into some things about his falconry license, exotic pets, as far as the findings that she has as far as her ruling.
Yeah, important to note again, he was claiming residence in a spare bedroom in a friend's home. He didn't even start paying $500 per month until this story was broken in the New York Post. Finally then, as we move forward, can you just speak to the significance of this ruling? Because again, if he is taken off the ballot in the state of New York, this could happen in states all over the country where he also claimed New York residency.
Well, the fact is that states have a lot of leeway as far as ballot access, as far as who they let on the ballot and who they don't. Some states, it's very easy for a third party or an independent to get on the ballot in a general election, and some places it's not. Kind of the interesting thing that we've seen here is that a lot of these challenges have came from Democrats trying to get Robert F. Kennedy Jr. off the ballot. But what we're seeing in some polling is maybe indicating that he might actually be taking more from the Trump campaign than the now Harris campaign, which this is something that, if we look at some presidential elections, think of 2016, 2002, the 2000 election, where, for instance, Jill Stein, Ralph Nader, where their margins, where the amount of votes that they got in certain states were enough that they could have flipped the election. So the fact that you have third and minor party candidates and independent candidates on the ballot have the ability to, in really close elections in states to change the outcome.
Yeah, looking at the politics of this in addition to the law. Professor Sean Donahue, thank you so much.